rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning, everyone, and welcome. For the record, I'm Charles Smith. I'm the presiding judge for this panel. My colleagues are, to my left, Judge Christopher Barta, to my right, Judge Ganel Metro, and to my far right, Judge Fergal Gaynor. Madam Court Officer, would you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you. I kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor, Mr. Holling.
Good morning, Your Honors. Appearing for the SPO today, Alex Whiting, Ward Ferdinandus, Nate Quick, Sarah Clanton, Sebastian Van Hooydonk, and my name is Matt Holling.
Thank you, Mr. Holling. And Mr. Kehoe for Mr. Thaci.
Yes, Your Honor, good morning. Sophie Menegon to my right, Bonnie Johnson to my far right, and on the Zoom is my co-counsel, Luka Misitic. President Thaci is present before the court.
Thank you. And thank you, Mr. Mr. Kehoe, I'm sorry. Mr. Emerson, please.
Good morning, Your Honours. I appear this morning remotely for Mr. Kadri Vasili, together with co-counsel who is in court, Mr. Andrew Strong, Ms. Annie O'Reilly, and legal advisor, Mr. Haradin Kuchi. Just to say one word, if I may, which is my apologies for not being there in person. I had intended to be, but I'm afraid I was diagnosed with COVID earlier on in the week.
We understood that and got advance notice, and thank you for reminding us, and we hope you have a speedy recovery. Thank you. Now, Mr. Young, for, let's see, Ms. Alejandra, Mr. Young, you're going to introduce the next witness.
As you like,
the next parties. Go ahead.
Your Honours, yes, as you know, I appear for Mr. Recep Selimi as counsel, and today I appear with co-counsel Mr. Jeffrey Roberts, Mr. Eric Tully, and Dr. Jacini Rossini. We are assisted today by Natalia Rychenko, case manager, and by Riva Gechai, evidence reviewer. Thank you.
Thank you, Mr. Young. Ms. Alejandra, please.
Good morning, Your Honours. Firstly, my apologies for not being there in person. I'm Venkateshwari Alejandra, appearing for Mr. Jakub Krasniqi. Together with me on video link is Mr. Aidan Ellis, co-counsel. Present in court are co-counsel Mr. Victor Bayesu, case manager Eva German, legal associate Melissa Gregg, evidence reviewer Jacopo Ricci, and support team members Durim Limai and Laura Abia. For the record, Mr. Krasniqi is present in court.
Thank you, Ms. Alejandra. Mr. Laws, we turn to you now on behalf of the victims.
Good morning to Your Honours and to everyone. I am Simon Laws, representing the victims in this case, together with my co-counsel, Maria Radziowska.
Thank you, Mr. Laws. Mr. Nilsson, we understand you are alone today. Is that correct?
It's correct, Your Honor. It's only me. Good morning.
Thank you for the registry. Now, before we start, I'd like to recall that on the 30th of November, this trial panel was assigned to this case by the President of the Kosovo Specialist Chambers in accordance with Rules 98 and 115 sub 1 of the Rules of Procedure and Evidence. Upon transmission of the case file, which occurred yesterday on November 30th, 2022, or I'm sorry, that's not correct. Yeah, the transfer was yesterday. On the 30th of November 2022, I was elected presiding judge of this panel by its members. With a view to ensure that no time is lost in preparing this case to go to trial, we have taken advantage of the short time before the winter recess to hold this status conference, and we thank you all for making yourselves available on this short notice. The primary reason for holding a status conference at this point is to enable us to get on with the planning and the commencement of the trial without undue delay. We didn't want 3 weeks of winter recess to go by without ensuring that all necessary preparations are being made to ensure that this case goes to trial as soon as possible. We believe it is in the interest of all that this case now moves to the next stage without delays. First of all, I would like to recognize all the hard work by all parties and participants during the pretrial stage. We are quite mindful and do not need to be reminded of the fact that this case is now entering its 3rd year, and the accused await trial in detention. You and the accused and the other participants can all rest assured that this panel will do everything in its power to fairly and expeditiously bring this matter to trial without undue delay and to manage the trial in a timely and effective manner. To that end, we intend today to give you some information, some direction, and some orders with strict deadlines that will enable a prompt scheduling of the opening statements and the calling of witnesses and the offering of evidence in this case. This practice will continue throughout the trial to ensure that proceedings remain focused exclusively on issues that are relevant to this case and so that the trial moves along at a reasonable pace. We must say that having read the pretrial briefs of the parties, we are encouraged that there are many issues that are not, or at least should not, be in dispute between the parties. We also take note of the degree of cooperation that is apparent from the record, both between opposing parties and between the various defense teams. This panel will encourage such cooperation, and it is certainly conducive to shorter and more effective proceedings. The responsibility to ensure that an accused is given a fair trial and an expeditious trial is the responsibility of all of us within the limits of our respective mandates. Now, as for today's session, we will proceed until about noon and take a half-hour break. We will then resume at 12:30 and continue until finished, hopefully by 2 p.m. If after our questioning we are finished and it is before noon, we will then break at that time anyway. And then we will come back with some finishing matters, including some oral orders. Just as advance notice and so that you can all start making some plans for the future, during the trial of this case, the hours in court will normally be as follows. First session from 9 o'clock till 11 o'clock, second session from 11:30 to 1 p.m., third session 2:30 to 4 o'clock. Only if exceptionally needed would we extend the hours beyond those stated hours. These hours allow approximately 5 hours sitting time on any day in court. This gives due consideration to the efforts of our excellent interpreters and the very difficult and tiring task of simultaneous interpretation that is necessary in a trial of this type. We are hoping to sit for 20 hours per week in court. First of all, we need to deal with the working language because it's provided for in Rule 8, Sub 3, Sub A of the rules. It requires us, after hearing the parties and the victims' counsels, to decide on a working language for the proceedings. The pretrial judge, in his decision on working language of 11 November 2020, determined that English shall be the working language for the proceedings in this case. May I take it to all parties that they are fine with the English being the working language for these proceedings? Mr. Prosecutor?
We are, Your Honor.
Mr. Kehoe?
Yes, Your Honor.
Mr. Emerson? Microphone, Mr. Emerson?
Sorry. Yes, Your Honor.
Okay. Mr. Young?
Yes, thank you.
Ms. Alejandra?
Yes, Your Honors.
Thank you. Mr. Laws?
Your Honor, yes, thank you.
Thank you. Now on courtroom scheduling in the future. As you all know by now, this courtroom is not reserved exclusively for this trial. Other pretrial and trial proceedings will be taking place in the same courtroom as this trial. We must accommodate those proceedings as well as ours. It is our plan for trial time in this case to proceed as follows. We are planning to sit 3 consecutive weeks, 20 hours per week, spread over 4 days per week, with Friday being generally reserved for activities other than court appearances. Then 1 week out of court, with that week taken by the other trial panel to allow you and the panel to prepare for the next sessions. We will then sit for another 3 weeks, followed by 2 weeks out of court, for the same reason, to allow the trial panel 1 to proceed. Then back to another 3-week session, followed by 1 week out of court. That pattern will continue to alternate 1 and 2 weeks out of court without change throughout the trial. Normal holidays and summer and winter recesses will be honored. Such a plan, we hope, will enable this panel to move forward as expeditiously as possible under the circumstances. This plan will allow us a maximum of 620 hours in court per year. At this time, it is our intention to convene this case in our courtroom for the opening statements by SPO and, if sought, by Victims' Counsel and Defense Counsel on the first day of March 2023. With a view to achieving this starting date, the panel will schedule a trial preparation conference pursuant to Rule 117 of the rules on Wednesday, 18 January 2023, and the Specialist Prosecutors Preparation Conference pursuant to Rule 118 in early February. Rule 117, Paragraph 1 provides that the panel shall hold a trial preparation conference with the parties and, where applicable, Victims' Counsel. The panel considers the participation of the Victims' Counsel appropriate and therefore invites him to attend the trial preparation conference. We now ask the parties' views on the schedule that I just outlined and also the plans to start the trial. Mr. Prosecutor.
Good morning, Your Honors. The SPO agrees that the schedule could ultimately facilitate fair and expeditious proceedings. We would just note that there should be some degree of flexibility, in particular in relation to sitting days per week, so that there is no unnecessary break or prolongation of the time that's required for a witness to travel or be available for testimony.
Well, we will come back to that at a later time, but the schedule will be quite rigid. We can warn you of that ahead of time. So you're going to have to make advance notice and advance placement with your witnesses to get them here and to have them here, and, as we'll say later, to have backups.
Understood, Your Honor.
Thank you. Mr. Kehoe.
Yes, Your Honor. We jointly, and this is the defense, proposed the end of March, and the reason is the witness protocol, which has significantly hampered our investigative efforts. As Your Honor is aware, we have been unable to contact SPO witnesses, albeit shortly before then. For instance, in my case, I had interviews set up extensively with international witnesses, which I had to cut off at the 11th hour because of the witness protocol. Currently, the witness protocol issue is on appeal, and we are seeking relief from the witness protocol, most specifically with regard to international witnesses. The instance that I was just referring to was a senior, extremely senior military officer who was more than willing to sit down and discuss these matters with me. And I, obviously, per the court's order, the pretrial judge's court order, I had to advise him that I had to postpone that until further notice. That is yet pending. That is now months and months old. So given the circumstances, and we have some other issues concerning SPO disclosures, disclosures coming at the 11th hour, which amount to, I think it's 66 redacted witnesses, or 54 within 30 days of trial, and then 46,000 pages in trial, plus this witness protocol. We would seek a trial date at the end of March, given the fact that we need some time for more investigative measures.
What date?
The last Monday in March.
That's your request?
That's the request.
We'll take that under consideration. Is that everyone's request on the defense? Mr. Emerson?
Yes, indeed, I support that position. I think it is the common position of the defense. May I indicate, I doubt that Your Honor would be wishing to hear submissions in detail about particular witnesses at this early stage of the process, but there's one There is one issue that we need to address, the terms of disclosure.
Just a second. I'd rather we come back to that at another time. Right now, we just need to know your view on the time to start.
No, exactly. For the reasons that relate to that issue, we think it would be necessary to start at the end of March rather than the beginning.
Thank you. Anybody else? Mr. Young?
We agree.
Ms. Alejandra?
Yes, we also agree.
Thank you. The panel would also like to state a few things about how it expects the parties to conduct themselves, though we assume much of what will be said would be obvious to all. First, in accordance with Article 10 of the Code of Professional Conduct for the counsel and prosecutors before the Kosovo Specialist Chambers, counsel and prosecutors have a general duty of candor towards the trial panel, and the panel expects that such duty will be upheld throughout the proceedings. Parties and participants shall also at all times demonstrate courtesy to each other in and out of court. Personal comments relating to and personal criticism of any party or participant will not be tolerated by the trial panel. Therefore, the parties will focus on what is relevant to this case, and we hope not to have to use our authority to sanction any such comments. All objections, comments, or other statements made in the courtroom shall be directed to the bench and not to opposing counsel. Parties and participants shall refrain from sharp tactics and shall as far as possible inform other participants in advance of oral and written applications they intend to make in court. As already mentioned, the trial panel also expects parties and participants to regularly discuss issues arising from the case among themselves with a view to finding solutions that do not require litigation or reduce the scope thereof. Communications with the judges are regulated by Article 11 of the Code of Conduct. Contacts by a party or other participant with the trial panel should in general be copied to or otherwise notified to the opposing party. The panel would finally highlight the fact that any problem that a party or participant has with the other party or with counsel acting on behalf of a party or participant shall first be raised in compliance with the Code of Conduct with the party or counsel concerned. When a dispute cannot be resolved, it shall be raised with the authorities provided for under the Code of Conduct or with the trial panel. Are there any comments on this?
Nothing from President Thaci.
All right, anybody? Raise your hand if you want to say something. Thank you. The responsibility to ensure that these proceedings are fair and expeditious is not only the obligation of the trial panel, but also of the parties and participants. The trial panel will not tolerate any delaying tactics by any party. It will seek to ensure at all times that proceedings proceed in a timely and effective manner. The trial panel expects the parties and participants to contribute to that goal within the scope of their responsibilities and in a manner that is consistent with the rights of the accused and those of participating victims. Extension of times will only be granted when clear reasons and justifications have been demonstrated. Furthermore, a party seeking such relief is expected to make an application for additional time in a timely fashion rather than at the last minute. Parties and participants' submissions, whether oral or in writing, should be focused and to the point. Parties and participants shall avoid lengthy speeches, repetitious submissions, or submissions in respect of issues not relevant to the proceedings. Any comments on this? Thank you. I want to make a statement in general concerning closed and private court sessions, as well as protective measures. The panel is guided by the fact that the trials are expected to be in public, so that the public knows and has confidence in the judicial process, as well as an understanding of the issues and decisions in that trial. This belief is reinforced by our law and the rules of procedure and evidence which demand publicity, subject to certain qualifications. Private and closed sessions of the court proceedings should be used sparingly and be the exception rather than the rule. Counsel are instructed to plan their direct and cross-examinations carefully, and in so doing to endeavor to group together any questions that must be asked and answered in private or closed session so as to avoid the need to move to closed or private session repetitively. Counsel should be prepared to justify briefly why they request the going into private or closed session. I now turn to the specific issues of redactions and withholding of documents, which has a direct bearing on the question of publicity in these proceedings. Redacting names and information that might identify witnesses, victims participating in proceedings, and other at risk on account of information they gave or their participation in the proceedings might be necessary to guarantee their effective protection and is permissible under our legal regime under certain conditions. However, such measures must at all times be consistent with the effective protection of the rights of the accused, in particular their rights to be informed promptly and in detail of the nature and cause of the charges against them and to have adequate time for the preparation of their defense. The need to guarantee a sufficient degree of publicity of proceedings will also be relevant to deciding what redactions are necessary and proportionate in the circumstances. The necessity and proportionality of the proposed redactions will therefore have to be clearly demonstrated by the relevant party. The panel notes that a large number of redactions and/or the withholding of a large number of documents have been authorized during the pretrial phase based on the fact that they were necessary and proportionate during that stage of the proceedings. Now that we are about to commence trial, it is the view of the panel that many of those redactions are no longer necessary or proportionate. If kept, many of these redactions would constitute an impermissible interference with the fundamental rights of the accused. The panel will therefore take steps in successive stages to ensure that information not yet known to the accused will be made available to them so that they can effectively prepare and present their case at trial. There are three categories of regulations presently affecting the defense. First, those contained in the indictment. Second, those contained in witness statements and exhibits which pertain to the first 40 witnesses that the SPO is planning to call at trial. Third, those in statements or of other witnesses and exhibits on the SPO's list of witnesses and exhibits. I will deal with these in turn. Turning first to the redactions contained in the indictment. We have counted 70 pending redactions. 58 of those are scheduled to be removed 30 days prior to trial, which on the current schedule will be, if we adopt the current schedule, will be 1st of February. Actually, it would be the 30th day of January. The remaining 12 redactions are scheduled to be removed 30 days before the testimony of the witness in relation to whom the information pertains. Except for one witness with the implications on one redaction in the indictment, there is no indication as to when the other witnesses concerned might be called by the SPO to testify. Consistent with Article 21(4)(a) of the law and Rules 86, 88(2), and 124 sub 2 of our rules, the panel would like to indicate that it is planning to order the removal of all redactions in the indictment as far as the defense is concerned, no later than 30th of January 2023. The SPO will have to demonstrate the need to maintain any redactions in the public version of the indictment in accordance with Rule 88 sub 2 of our rules. The removal of all redactions in the indictment as far as the accused are concerned should enable them to get timely and detailed notice of the nature and cause of the charges against them and have adequate time to prepare. Secondly, we take the view that while many of the redactions in the disclosed evidentiary material, which the SPO plans to use at trial, might have been necessary and proportionate at an earlier stage of the proceedings, many of the redactions have become unnecessarily cumbersome and could be an impediment to the timely preparation of the defense and to the prompt and effective conduct of this trial. Based on this, it is our preliminary view, I note that again, our preliminary view, that all redactions contained in the evidentiary material that the SPO plans to use or to show to any of its first 40 witnesses including any witness's statement that the SPO plans to use or tender, should in principle be removed 30 days before the commencement of the trial. That includes the disclosure of the identity of, we believe, 7 of the first 40 witnesses that the SPO intends to call, in relation to whom the pretrial judge ordered delayed disclosure up until 30 days before testimony. Under the regime in place during pretrial, the identity of these 7 witnesses and their related evidentiary material were scheduled to be disclosed 30 days prior to their testimony. The panel is intent on ordering that this be done instead 30 days prior to the commencement of trial, in other words, on 30th of January 2023. Now, as the panel sees it, there are 2 ways in which the SPO can respond to such an approach. One is to call these witnesses early in its case so that, in effect, the protective measure of disclosure 30 days prior to testimony remains in place, or the SPO can ask the panel to grant other, less intrusive measures to deal with any remaining security concerns in respect of those witnesses. For instance, the panel might entertain, in relation to those 7 witnesses, any application by the prosecution to subject the use of the defense and victims' counsel of information pertaining to these 7 witnesses to contain conditions or limitations. The panel might also entertain any application from the SPO to vary its list of the first 40 witnesses that it intends to call at trial, in order to ensure that all redactions in the indictment can be lifted by 30th January 2023. If the SPO is unable to arrange for any particular witness to testify in the first month of trial to achieve this aim, the panel would like to know why this is so. But we leave it to the SPO to decide what submissions it wishes to make on these issues. In any event, we want to make it clear that, consistent with the orders of the pretrial judge, protective measures in relation to these matters will continue to stand in relation to the general public. Concerning the 3rd category of redactions, namely redactions in the statements of other witnesses and exhibits on the SPO list of witnesses and exhibits, we plan to adopt a similar approach and order the removal of redactions for each new group of SPO witnesses that are going to be called in succession each time notice is given of the next group of SPO witnesses. We will now give each of you the opportunity to state your views in respect to these issues and to make additional written submissions before we render our decision on this matter in January. Please be mindful that we will simply not allow a continuation of the redaction system as it currently stands as we approach trial. From the SPO first.
Thank you, Your Honor. I'll address these. For the first of Your Honor's 3 orders in relation to the indictment, we understand will comply by the deadline indicated. On the second one, we also understand the terms of Your Honor's orders. We will evaluate what applications are necessary for the...
Mr. Howling, this was not an order. This was a statement of what we intended.
Thank you. But in relation to the statement of intention, we will work within the framework that Your Honor has set, and we can accept that. We do need to evaluate what applications would be necessary in relation to the 30 days before testimony witnesses, and so we would revert on that, back on that. And for the 3rd order, we understand and will comply.
Thank you very much. Mr. Kehoe.
Yes, Your Honor, just briefly, we appreciate the redactions on the indictment themselves, Your Honors. That will assist us tremendously as we move forward on there. With regard to the witness indictment redactions that Your Honor alluded to, that would include, I suspect, the 46,000 pages that was scheduled to receive on the cusp of trial.
We weren't counting the pages.
No, I don't know the number of the pages. I got the 46,000 page number from the SPO, who told us that our post-Christmas present, if at this stage, was going to be 46,000 pages of documents on top of everything else that we were supposed to digest and investigate 30 days before trial. With all due respect, Your Honor, this was addressed with the pretrial judge. Obviously, the order was the order, but we are at a point. We are removing redactions and trying to get disclosures. So if we could move that date up as to an earlier date, it would be helpful 46,000 pages is difficult to read in 30 days, much less digest and find out exactly where it's going to be deployed, or our resources are going to be deployed. I say that, Judge, somewhat in the abstract, because I don't know what's in those documents. I suspect the 46,000 pages of documents are going to be significant, or we would have received them previously, or there are other concerns, whatever it happens to be. But it's still a lot of information. It's still a lot of information to get through on top of everything else. So we would respect, I'm sorry.
So on the 40 witnesses, you want an earlier date?
Well, on the 40 witnesses, we would, the documentation. There are two issues. The one's the documentation, it's the 46,000 pages that we're getting on the eve. With regard to the witnesses themselves, yes, we would want them before, but it would help, Judge, if we had the order of their witnesses. If we had the first, what's their first 20?
We're going to get to that in a little bit. So I understand. You'd like to have the documents sooner.
Basically, Judge.
Okay.
You said it much more succinctly than I.
Thank you. You'll find we're going to be succinct quite often.
I trust, Judge, that would be the case.
Thank you very much.
Okay. There is one.
Oh,
just
go
one-
ahead, go ahead.
There is one matter with regard to these 40 witnesses that, Your Honor, I think we're going to have to take that in private session. I don't want to delay matters now, but I would like to address that at some point.
Today?
Well, it'll just be very brief concerning the disclosure of those witnesses because they do pertain to each other.
Okay. Thank you. Mr. Emerson?
Your Honour, I wanted to return to the issue I flagged up earlier on, and it relates, and I'm not going to mention any details, but it relates to the witness that Your Honour referred to when speaking within categories 1 and 2 of a witness who relates both to redaction on the indictment and to significant redactions in the witness's testimony. This issue was raised in advance in writing with the SPO, and there's been inter-parties correspondence about the question of raising it in front of Your Honours today. It is rather important on the scheduling questions that Your Honour is deciding, and the SPO at this stage have requested that I apply to go into private session before addressing the bench. This is me making that application at their request, but since I need to refer neither to the name nor to the number in the context of the submission I'm just about to advance, because it's perfectly clear that Your Honour has identified the one witness that these submissions relate to. I personally wouldn't support that application, but if it might be right to just hear from the prosecution at this stage on whether it needs to be addressed in private session.
Mr. Howling?
Thank you, Your Honor, and we appreciate that the Viselli defense gave us advance notice of this. The discussion that Mr. Emerson is proposing to have is about one of the most protected witnesses in the entire case, and it's extremely sensitive, and so we don't know exactly what the content of the submission is, but this is why we ask that these submissions be in private session.
All right. Thank you. All right, Mr. Emerson, what we will do is we will consider that together with Mr. Kehoe's request for a private session and deal with it later on. All right?
Yeah.
Thank you. Mr. Young.
Yes. Your Honour, I can be very brief. In short, we welcome the generality of the points you make in relation to lifting of redactions. That's welcome news because clearly the defence have to know the case that they're facing as soon as possible. And given the size of the expected disclosure as a result of the lifting of redactions, the sooner we are given the material, the better. Because obviously the lifting of the redactions will mean undoubtedly more investigations, further preparation work. So we ask for it to be received by us as soon as possible.
Thank you.
And Mr. Roberts will address you on another matter.
Thank you. Mr. Roberts.
Good morning, Your Honours. Very briefly, am I led to believe that the redactions to the pretrial brief and to the outline will also be lifted at the same, or it's your intention to lift them at the same time? There are obviously overlapping redactions and extensive redactions to the pretrial brief, which also prevent our preparation. So we would request that they be lifted at the same time as redactions to the indictment.
Thank you. That's noted. That's noted. Thank you. Ms. Alejandra, or whoever's speaking?
Mr. Ellis is going to address you on this matter.
Okay, Mr. Ellis.
Thank you, Your Honour. I'm mindful also of the need to avoid repetitive submissions, and we support much of what's been said before by the other defence teams. Can I just add my particular support to the submission made by Mr. Kehoe that we would seek to receive the material more than 30 days in advance of the trial in relation to those first 40 witnesses. In relation to witnesses that were due to be disclosed 30 days before trial, we heard from the prosecution that there were some 46,000 pages either to be disclosed for the first time or redisclosed with redactions lifted. And I think I made the point in previous status conferences that would require us to read more than 1,000 pages a day in those 30 days running up to trial, ignoring all of the other tasks we've got to do, and assuming that reading them once is sufficient, which of course it isn't, because there needs to be a process of analysis. So we would seek to bring that deadline forwards so that we receive the material in sufficient time to prepare it for trial.
I want to come back to Mr. Howling. You've heard the request by the defense. Do you have any comments on that? Is that a possibility as far as you're concerned?
Yes, Your Honor. There were multiple requests made. I can talk about the feasibility of each.
Okay.
In terms of receiving the materials earlier, the schedule set up by Your Honors is preserving the 30 days before trial protective measures that the pretrial judge imposed, but just by the dates of 30 January to 1 March. Those protective measures have been deemed necessary and proportionate, and there is no explanation given as to why that timeline should be varied. In terms of the 46,000 pages, there's a couple of points that may be of assistance as to qualifying that number. One, not all of the pages are new. These pages are often going to be lesser redacted versions of things already provided. The second one is that this 46,000 number is pages in all languages where non-standard redactions have been applied, English and Albanian. So the actual number of pages that needs to be processed in advance of trial in English is going to be closer to half of that number. And so we just wanted to qualify both the scale and the timing. Thank you. Oh, sorry, one last point. On the pretrial brief and the outline, in our submission, that's different from the indictment. Mm-hmm. The indictment, we actually reassessed the redactions and actually thought that a reclassification of the indictment would be feasible at the moment of 30 days before trial, which is precisely what Your Honors ordered. But the pretrial briefs and the outline have detailed summaries of evidence of witnesses 30 days before testimony, and the redactions cannot be lifted in the same way.
And one other thing, they jointly have requested an end of March start date rather than a 1st of March start date.
It's our submission that the trial can proceed aligned with the schedule that Your Honors set out. We understand that the start date of the trial is within Your Honors' discretion, but we see no reason why the trial can't start on the 1st of March the way you originally ordered.
There would be possibly the option of taking opening statements on March 1st and commencing with the evidence at a later date. Any comments on that possibility?
My comment on that, Judge, is...
Excuse me just a second.
While we have had this discussion about the 46,000 pages over a many-month period of time before the pretrial judge, today was the first day that we've received some explanation as to what was in those documents.
Progress is progress.
Progress is progress. It's all perspective. You're absolutely, be that as it may, Judge, it still leaves us in the dark of exactly what we're looking at. We're still going to receive a significant amount of information and tremendous amount of unredacted information from witnesses that we would not otherwise have had. That information has to be digested, and certainly for the court's benefit, the digestion of that information will be incorporated into an opening statement. Mm-hmm. So we would like to fully explore all of this evidence, examine it, before we stand before Your Honors as officers of the court to give a fulsome opening statement.
Thank you. Mr. Emerson?
In order to address Your Honour on that question, I'm afraid takes us back to the issue that Your Honour's put to the back of the agenda in terms of
Okay.
questions that need to be raised in closed session.
Fine, thank you.
I'll be questioning whether they.
We'll deal with that later then. Thank you for your advice. Mr. Roberts.
Your Honour, simply, we support Mr. Kehoe's submissions in relation to later date. Clearly, the disclosure that we receive may affect opening statements if they're to be made. So we fully support the Thaci position.
Sorry, Mr. Young, for referring to you as Mr. Roberts. Ms. Alejandra or Mr. Ellis?
We support the previous submissions made by Mr. Kehoe and Mr. Young on the earlier disclosure of this material. Thank you.
Thank you.
And
Judge Matro has a question.
Thank you, Judge Smith. And the question is for you, Mr. Kehoe. I understand that on the issue of the starting date, you have raised two concerns or justification for not starting on the 1st of March. The first being the witness protocol, which, as you pointed out, is currently under consideration before the Court of Appeals panel. In the issue of disclosure, my question to you is this. You now have the list of the first 40 witnesses which the prosecution wants to call as part of the initial presentation of its case. Is any of these witnesses those that you wish or intend to interview prior to trial? In other words, are any of these actually affected by your challenge to the witness protocol as it exists? And the second question, which maybe you can address at the same time, is any of the disclosure issues that you currently have affecting your preparation in relation to any of these 40 witnesses?
The first question first, Judge Matro. Yes, the protocol does affect the several of the first 40 witnesses. In case in point, the international witnesses, I can tell you specifically, without mentioning the particular witness's name. It is a witness that is on the SPO's witness list, but he is also one of the witnesses that we advanced to the pretrial judge to take his deposition or statement out of order before the chamber. So that is not the only one, but it is one of the most immediate concern. He is, again, one of those witnesses that I spoke to as an officer of the court. I spoke to him preliminarily, but as any follow-up, Judge Matro, I was precluded from doing so because of the protocol. Now, this is a witness that is, I suspect, going to be called early on in the proceedings, and is a witness that we want to spend a significant amount of time with, that has had significant activity in the theater in 1998 and 1999. Now, with regard to the second issue, Judge Matro, the specifics are everything. The redactions that we are going to get on these 40 witnesses, yes, they gave us the witnesses that they're going to call, but if Your Honor examines the statements that have been handed over, there are significant redactions from all of those statements that don't give a fulsome explanation of exactly what these witnesses are going to say. Some of the redactions are remarkable in the sense that they delete dates, they delete locations, put aside the fact that other witnesses, that other people who would have been involved. So all of those matters play into our ability to examine those particular witnesses. As a case in point, Judge Matro, the pretrial judge had asked us, me specifically, on numerous occasions about an alibi notice. And I informed him that given the redactions that are in the charging documents and statements, it was virtually impossible. I said, what we did try to do, it's not about me, it's the we, what we did try to do is, in our pretrial brief, give a brief outline of where President Thaci was during some operative time frames. Whether that answers the alibi question or not, I can't answer that without more specific information. And unfortunately, Judge Matro, that takes time and effort to pin down dates and times and where somebody was and where they were traveling. That's just the case in point. But that's not the only issue. I take that as a salient issue because it was an issue that came up quite frequently with the pretrial judge.
Thank you.
Your Honor, if we could be heard on relation to the recent submissions. Thank you. First,
Go ahead. I'm sorry, my mic was off. Go ahead.
Thank you, Your Honor. First, in relation to the protocol, this has been raised by the defense before. The defense has phrased this protocol as blocking their investigations, which is a misrepresentation of the protocol. The protocol just sets modalities for contacts with opposing party witnesses. The Thaci defense, and actually none of the defense teams, have ever attempted to use the protocol by its own terms. This is a decision the defense teams are making off of the decision and not an actual limit imposed by the pretrial judge. But more generally, in relation to the options given about splitting the opening statements that was suggested by the panel, the SPO would very much like to start the evidence immediately after the opening statements. So if there is interest in accommodating what the defense is asking for of a small delay in the proceedings into March, our personal preference would be to actually delay both the opening and the evidence into March. Thank you.
Thank you.
May I have just a brief response to counsel's argument on the protocol?
Yeah, I don't want to really get into a litigation on the protocol. I understand somebody else is doing that, so go ahead.
Yes, I understand.
You go right ahead, but make it short.
Your Honor, the protocol was calling upon us to bring the SPO into any defense interview of any witness that was then going to be filmed by the registrar's office. So our preliminary interview of a witness to trying to investigate matters is going to be filmed, put on file, and used by the court if need be, all with the SPO sitting in the room. Now, as that presents a hurdle, if that doesn't present a hurdle to the defense investigation, I stand corrected. But with all due respect to my learned friend, I've been doing this a long time, as your honors have. It's a significant hurdle.
Thank you very much. Mr. Laws, I didn't mean to ignore you. Do you have any comments on the redaction discussion and the private and closed session discussion that we've already had?
Your Honor, no. Safe to say we assume that we will also receive the material in its unredacted form, but we've nothing to add.
Thank you very much. Are we finished with this subject? Anybody else? All right, we'll move on. Concerning issues that will be raised and their relevance, in order to ensure a fair and expeditious proceeding, this panel will be firm in excluding and disallowing lines of questioning or attempts at tendering evidence that are not clearly relevant to this case. The panel notes in this regard that it will not entertain on the part of the parties historical narratives that are not demonstratively linked to the resolution of this case. The panel further notes that contrary to what has been claimed, the Kosovo Liberation Army is not on trial in this case. If that is the defense's understanding of the SBO case, that is not an understanding that is shared by the panel. 4 defendants are on trial here and no one else. Similarly, the suggestion that the SBO's case is that the creation of an independent Kosovo was the result of a criminal plan is again not the understanding of this panel, nor is it pled or averred in the indictment. Now I'll turn to the submissions which appear to suggest that Serbian forces committed a large number of serious crimes against Kosovo Albanians and others during the relevant time period. The defense appears to suggest that some of these incidents in which crimes were committed affected the operations or efforts of the Kosovo Liberation Army to structure itself. Regarding the suggestion of serious Serbian crimes being committed during the relevant time, may we take it that the SPO does not dispute that fact and that, if that is the case, there will be no need for any further submissions or discussions of these matters at trial? Mr. Prosecutor? Is this being disputed, or is it in fact admitted that these things occurred?
That is, we are in agreement with the position you just expressed.
Thank you.
That is not disputed.
So with that clarified, the suggestion of Serbian crimes can be regarded as not being in dispute here, so that there's even less reason to tell us about those. Furthermore, if the defense wishes to demonstrate that a given incident associated with Serbian crimes impacted the functioning or operations of the Kosovo Liberation Army in a manner that is relevant to the case of the prosecution, it will of course be permitted to lead evidence of that fact. At the same time, the panel will not entertain evidence of Serbian crimes simply because it is said to give a broader and more complete picture of the events in 1998 and 1999 in Kosovo. This panel and the parties are only concerned with events and circumstances that are relevant to these accused. We are not a historical association, and we will not permit the parties to turn this trial into a history lesson. Is that understood by everyone? Mr. Keogh, I see you getting to your feet.
Yes, Your Honor. I mean, obviously, at the appropriate time, we will discuss the relevance of particular, Serbian crimes contextually with what's happening on the ground.
That's our only request. Let's make it relevant.
Absolutely, make it contextual. I understand.
Anybody else?
May I just
Yes,
say
go
one?
ahead, Mr. Emerson. I wasn't going to skip you.
No. Clearly, we have set out, I hope clearly, in our pre-trial brief, the particular ways in which we have suggested that those issues may touch upon some of the questions and inferences that the prosecution are inviting the trial chamber to draw, a number of which depend upon the intensity and frequency of the number of incidents on the indictment, and clearly some examination or agreement about context is important to be able to test the reasonableness of the inferences that the prosecution are seeking to draw from the alleged pattern of events. From the defence point of view, we, as far as Mr. Vasili is concerned, have sought to confine ourselves to a very significant extent to findings that have been made by trial chambers or on appeal by the ICTY in respect of those matters, which can be dealt with very briefly as adjudicated facts, if that's the way that the court would prefer to deal with it.
Thank you, Mr. Emerson. I think our statement is quite clear. Relevance is going to be important. We're going to carefully monitor that. This trial needs to be over within our lifetimes, especially within mine. So we will be carefully watching the evidence that comes in, and we will want to make sure that it has to do with the allegations against these 4 individuals alone.
Your Honour, if I may, on that issue.
Yes, go ahead.
Your Honour, sorry, it's Mr. Ellis for the Krasniqi defence. We had also set out our position on this issue in, I think it's paragraph 54 of our pre-trial brief. We appreciate and we will demonstrate relevance of the evidence that we seek to adduce when we come to that point, and we'll be very mindful of the instructions that Your Honour has given this morning. But we would see that the evidence about Serbian crimes in specific locations at specific times may be relevant to issues going to the alleged common purpose in this case, and indeed to the motivation of individual KLA members who the prosecution will suggest committed crimes in those locations. So understanding that we will need to demonstrate relevance when we seek to adduce that evidence, we do highlight that we've sought to do that already in our pre-trial brief. And it is perhaps worth saying that we had tried to put agreed facts to the prosecution on Serbian crimes, which were all rejected by the prosecution. So we would say the specifics do matter, and it's not simply enough for the prosecution to say they do accept crimes were committed in a general sense. We've tried, and we can try again to seek agreement on specific crimes, if that makes things more efficient.
We always encourage cross discussions with the opposing parties. It can't hurt you. We now will have some questions for some of you. Each of us will have something to ask, I notice. I will ask the first question, and I direct it to the SPO. How does the SPO intend to present its case in general terms? In other words, will witnesses be called by categories, such as crime base or alleged command structure in any particular order, or will the SPO follow a chronological order or some other method?
Your Honor, thank you. The SPO will endeavour to order its case in a manner that allows the court to best understand and process the evidence and also serves the twin goals of fairness and efficiency. This requires us to balance many factors, including the availability, security and well-being of witnesses and the ability of the defence to investigate and prepare. And we note there is not one logical order for us to present the evidence in this case. The evidence is interlinked not only chronologically and geographically, but also thematically, for example on themes of command and control, notice, categories of opponents, and individual roles of the accused or other JCE members. Numerous witnesses will give evidence relating to multiple crime sites, multiple JCE members or tools, and different time periods. And for all these reasons, we cannot tell you that we will order the evidence by any of those particular strands, but we need to take them all into account. So we will have to consider and balance all factors.
You're telling me you don't have a plan as how to proceed at this point? Who's going to be the first witness? Who's going to be the second witness? Is it going to be on command structure? Is it going to be on a particular crime? Or at this point, I would think you would have some idea.
Your Honor, we certainly have plans and ideas, and we are ready to submit them to you. All I meant to say is that I can't tell you that we will proceed to order the evidence either chronologically or geographically or by crime site or by theme, but that we will take all these factors into account when ordering our witnesses. So to give you an example, we have some international witnesses who interrelate to different crime sites, different victims, different time periods, and different roles of the accused. And we believe it will be beneficial to understanding the evidence to take into account what they will testify about and see which witnesses will be logical to have them testify either before or after in order to best understand the evidence. So yes, we are ready to inform you in more detail about how we are going to proceed. We think that will best be done in writing because it will allow us to be more specific about the witnesses, and we can do so for each block of witnesses.
By the time of our trial preparation conference, you can have that in writing for us.
Well, we also submit that experience shows that organization of the evidence in trials of this nature is best done in tranches, and that we will have to balance the need of timely information to all involved with the need to make these decisions on a realistic timeline. So we believe it will be beneficial if we can show you the order of our witnesses for each block of witnesses.
The block of witnesses we've asked for is 40 witnesses. And we will have another order dealing with a smaller group on more of a weekly basis. So I'm still asking you, can you have you've told me you can present this in writing, and will it be presented by the time of a trial prep conference?
Your Honor,
that's a very simple question.
Your Honor, we are obviously ready to submit in writing what you require us to submit in writing.
All right. Well, it will be required, and it will be required by the trial prep conference. Thank you. Judge Gaynor, I believe you had a question.
Thank you, Judge Smith. This question is also for the SPO. When is the SPO planning to request the admission of written statements pursuant to Rules 153, 154, and 155? And in particular, will the SPO file all of its Rule 155 applications relating to deceased witnesses as one consolidated application?
Thank you. Your Honors, I will address this question. The SPO has submitted a streamlining filing in which we've indicated that we will be submitting our applications for 153 and 154 witnesses before the commencement of trial, our first applications, that is. It will be the same for the Rule 155 applications. In terms of your specific question about the deceased witnesses, to the extent that we are able at this time to submit them in one consolidated application, we can do that. However, there are some factors which are still under consideration. For example, we are in the process of receiving documentation, including death certificates and medical reports for certain witnesses. This is an ongoing process that we've been engaged in during the pretrial period, and all efforts are being made to expedite the receipt of these documents.
That's fine, thank you.
Thank you, Judge Smith. And this is a couple of questions for the SPO as well. It has to do with 154 and 153, but in particular the requirements of form contained in Rule 153, paragraph 2, which requires the presence of the signature of a number of individuals, the interviewee, the interviewer, and, as the case may be, counsel representing the interviewee. Now we've started acquainting ourselves with some of the material which you propose to offer under these rules, and they are, for the most part, records of interviews taken not in the form of a, strictly speaking, a statement as maybe traditionally taken, but really a verbatim record of interviews. Now a question for you is, are you saying that these type of records fulfill the formal requirement of Rule 154.2 if you were to seek to rely on that rule? And if so, on what basis? And the second question, maybe I'll put them both to you so you can address them together, is our understanding correct that if and when you will seek to tender statements under either of these rules, 153 or 154, these will be tendered for the truth of their content and for no other purpose? Is that a correct understanding, or is it one that needs to be qualified?
Yes, Your Honor.
Before you start, Judge Gaynor corrected me. I need to be corrected by Judge Gaynor quite regularly. It was 153, and I apologize, and I'm grateful to Judge Gaynor.
Yes, Your Honor. As to your first question, the SPO's position in respect of Rule 153.2. So as you'll be aware, Rule 153.1 specifies that witness statements or transcripts of evidence in prior proceedings can be tendered pursuant to this rule if the conditions are met. The requirement of a signature in Rule 153.2 doesn't apply to transcripts of evidence in prior proceedings before the KSC based on the wording of the rule, and also, this is logical, we would submit, typically transcripts are not signed by a witness, transcripts of testimony in particular. We submit that this should extend to transcripts of recorded interviews, which are also tendered under Rule 153.1. There's no issue of reliability, authenticity, or probative value raised by the fact that we're tendering records in the form of a transcript which are not signed. There are indicia of reliability in the transcripts of the recorded interviews, similar to the ones required in Rule 153.2, that being that the witness will have been identified, the record has the date, the time, the place, and the attendees as specified in the rule. As to your second question as to whether, if and when we tender statements pursuant to Rule 153, if they're being tendered for the truth of their contents, the answer is yes.
And just a quick follow-up, it's a yes exclusively, or it's a yes that needs qualification? The statements will be relied upon for the truth of their content, correct?
There may be an exceptional basis where that is not the case, but for the majority, I would say nearly all witnesses, the intention is that we are tendering witness statements for the truth of their contents.
And just on your point, on paragraph 1 of Rule 153, would your submissions be similar if the record of interview is not one taken by the SPO but by a third party, that there's no formal requirement of signature for admission under that rule?
In that situation, it would depend on whether the record of the interview is prepared for the purpose of legal proceedings and has all of the attendant indicia of reliability that you would have, including those that I mentioned, the fact that the people are identified with the date, time, place, and the witness is identified.
And I have a second question. I don't know if you are the person to ask, but it's certainly someone from the SPO. It's about protective measures for your witnesses, and in particular the first 40 witnesses. Now, a number of measures are in place. They've been ordered. We are quite keen to avoid any last-minute application for variation of these measures. We do understand there might be a situation where you might have to do so because of particular circumstances pertaining to this or that witness. What we would like to know is whether steps have been taken already by the SPO to ascertain with your witnesses whether any of the orders for protective measures that are currently in place need to be varied. And if the answer to my first question is not yet, when is the SPO planning to take steps to ascertain whether witnesses still need the protective measures that have been ordered and or require additional measures? Thank you.
Thank you, Your Honor. I can address this question. We're in communication with our witnesses about their protective measures. If variations of protective measures have been necessary, we have already reported that. There's a notification procedure if we're changing protective measures to provide further information to the defense. If there is the need to request further protective measures, we've been doing so. So we're not anticipating last-minute variation requests of protective measures coming to this trial panel. We've been trying to request them in advance as much as possible. Should there be any variations of protective measures, such as a witness wanting to waive protective measures, we'll promptly report that to the trial panel, and we can follow the same procedure set out in the Gutsadi and Haradinite conduct of proceedings.
I'm grateful for the indication. Thank you.
Judge Barta has a question. I haven't forgotten about the defense. We will ask you to make comments on all the questions that were asked in just a moment. Go ahead, Judge Barta.
Thank you very much, Mr. President. My question is also for the SPO. The panel has taken note of your time estimates for the first 40 witnesses to be called at trial in the annexes to your submission of 18 November 2022, and would like to know why you need so much time for your Rule 154 witnesses, sometimes more time than you calculated for a witness who testifies live. Why do you need, for example, 6, 9, or even 13 hours for a Rule 154 witness, particularly in view of the fact that Rule 154 serves to expedite the proceedings?
Yes, Your Honor. The SPO has made our provisional time estimates for the length of direct examination for the Rule 154 witnesses, but I want to make clear that our objective in every case will be to use less time than foreshadow where that is possible. The time estimates reflect the reality of the Rule 154 process. There are formalities, there are questions that have to be asked to every Rule 154 witness, which take up court time. There's also the issue that we wish to call 154 witnesses and allow them to highlight or clarify or explain certain elements of their evidence. We will also use this time if a witness is the appropriate witness to comment on a particular exhibit, and we think it would be a worthwhile use of court time to do that. We also would like to be able to ask witnesses questions with an appropriate witness about the impact of the events on their lives if they're victims, for example. Another reason why we would call 154 witnesses and ask for additional time is that they may be uniquely placed to talk about events, because due to the passage of time, they might be the only in-court witness who can comment on that.
Thank you.
Now we'll turn to Mr. Kehoe, if you have any comments on any of those submissions.
Yes, Your Honor, and I hope I remember them all, but I will start with Your Honor's first question to the SPO concerning the organization of trial. My reaction was similar to yours, having done cases on the prosecution side quite extensively, that they don't know the order of their witnesses or how this is going to proceed. It's somewhat alarming at this point that they don't know the lineup of their first 20 witnesses.
Point of order, Your Honor. It is unacceptable that counsel put word in my mouth that I did not speak. I understand your question. I think we may have had a misunderstanding. It's quite clear that we know the order of our witnesses, and counsel should refrain from attributing words to me that I did not say.
Okay, that's fine. Go ahead and finish your statement.
And what we're looking for at this point, Judge, is some roadmap as to how this trial is going to proceed. So we can do it expeditiously. If we have to take up, Rule 154 applications or 153 applications, we can do so expeditiously and we'll be ready to do it. This all flows together, as I'm sure Your Honor knows, to get an idea of what's coming, What do we need to do? How do we need to address the 153, 154 issues so we can do those quickly and we can cut down on the time? Now, the second issue concerning Judge Gaynor's question on the 153 and 154, excuse me, the 154 and 155 applications, obviously we are not going to object across the board to all of those statements. I can say that as an officer of the court now, but there are several of those statements which could prove extremely problematic for a variety of reasons, and that turns to Judge Mitro's question concerning 153.1 and 153.2. And what, unfortunately or unfortunately, I think the experience that most of us have had in other international tribunals is that we didn't have transcripts from third country or third entity proceedings. In this case, be it ULEX, UNMIC, or actually Kosovo courts. Do they present itself with the indicia of reliability sufficient to meet the test under 153.1? It may, Judge Mitro, it may not. And I think that's a case-by-case question. We're not saying across the board that they cannot meet that standard, but we're talking about a different time and a different place, and certainly the witness akin to 154.2 is not reading his prior transcript that he or she may have given in another proceeding in another time and attested to that. That simply didn't happen. That in our common experience of witness statements, those statements are read by the witness, signed or initialed by the witness, and then signed at the last page. With the use of all of these depositions, I submit to Your Honor, it is the rare case where that transcript is given to the witness and say, witness X, is this everything that you had to say, and do you want to make any changes in it? That being said, there are going to be challenges to those submissions, and we will just, on the relevance issue, Your Honor, we're going to take that up on a case-by-case basis. With the protective measures, I'm encouraged by the comments by counsel to say that they are monitoring their witnesses to see if they still need protective measures. We have brought to the attention of the SPO on various occasions that their witnesses have given public statements on TV or in the media in Pristina, and asked them to take that into consideration whether or not protective measures are still warranted. Some of the people that have made those public statements are still protective witnesses as we speak, and we encourage the SPO to revisit that issue as often and as necessary to ensure that if a witness does not need protective measures or has waived it or done something to undercut the entire procedure, that those measures are lifted.
Thank you, Mr. Kehoe. Mr. Emerson, anything to add?
No, I sound like a scratch record. The only comments that I have to make are matters that touch upon the issue that needs to be raised, on which your honours need to decide whether you'll be hearing submissions in open court or in closed session.
Thank you. Mr. Young.
I think to add, save that Your Honour may be aware that we served a note on the 18th of November, which deals with the 135 proposed facts, and the reality is that the prosecution replied on the 10th of November, and they informed us that the defence will not, in fact, that the agreed facts won't be agreed. It's very important, these are very important, because we set out 135 agreed facts in relation to Serb atrocities. They relate to the period of time of the indictments. They relate to very important features of the case, and it's welcome to know that the prosecution will not be objecting to the Serb atrocities, but we want the detail. We want the detail because it's going to be relevant to relevance of the charge that we face. So we want to know exactly what the position is in relation to 135. It may well be that they have changed their position from the refusal to accept 135 acts, but we have clearly stated that these are important, that we know exactly where we stand, and we've taken the liberty of setting them out in a public document, which Your Honour has. and which your Honour can see. Thank you.
Thank you. Mr. Ellis? Oh, I'm sorry.
Yep. We agree with the submissions that have been already made by the other defense teams, and we support them. We will respond in writing to when the SPO is will file for the admission of the statements and all other evidence under 153, 154, 155. And that includes the statements and the transcripts other than obtained by received not under the KSC but by other investigative bodies and courts, including ULEX, UNMIC, and so on. Thank you.
The defense has seen the first 40 witnesses, and you know the identity of some of them. And I will ask you, first of all, in general terms, and we'll begin with Mr. Kehoe, of those that you know, is there an extensive cross-examination for these witnesses, or have you been able to assess that?
I will tell you, Judge, and I'll give you a partial answer because I don't have a full answer to that. For the witnesses that I have reviewed and assessed, the cross-examination will be extensive. I can tell you, for instance, I have been spending time with my colleagues on the international witnesses because there are fewer redactions there. Those cross-examinations will be extensive.
What do you call extensive? I mean, are we talking a day?
Day. I would say a day. I don't generally do a cross-examination on issues that don't pertain to my client, for instance. Just going across the board, I will focus it on matters related to my client and the JCE.
And is the defense talking about these cross-examinations and thinking about possibly consolidating the cross-examination with one attorney handling one and another attorney handling another?
Not so much with one attorney handling one and someone else handling another, because it is very client-specific, as I'm sure Your Honor understands. But is there a discussion? And have I talked to Mr. Young, for instance, about what we might want to do with a particular witness? Of course.
Yeah, keeping in mind the timing, we just don't want to end up with extensive cross-examination over the same subject from each of you. I mean, it doesn't serve any purpose.
Yeah, and I agree with Your Honor. There will be always, in multi-defendant cases, I'm sure Your Honor has seen, there is some limited overlap, but I don't think it behooves us or the court to have extensive overlap.
No commando cross-examinations, though? In and out with a few questions.
Well, I shouldn't say that, Judge. I have done that in the past, especially in identity issues cases. I'm sure Your Honor's familiar with.
It's sometimes the best way to go.
It is.
All right, thank you. Mr. Emerson, anything to add about
this? Yes, briefly. So far as the Vasili defense is concerned, there is only on the witnesses whose evidence we know and have seen, that is to say, leaving aside the witness we're going to talk about at a later stage, there's only one witness in the first 40 that I anticipate would take a considerable amount of time as far as the Vasili defense is concerned. In fact, having cross-examined him in other proceedings, he's a witness who's testified in numerous cases. His evidence is generally covers a very wide compass and can go on for quite a while. I mean, I don't need to mention the name; it isn't protected, but it relates to internal KLA organisation and matters of that nature, which are going to be obviously important questions for the panel to deal with thoroughly. As far as cooperation is concerned, I mean, I personally regard that as just a matter of basic professional standards. But I mean, you will be aware, I'm sure, that the practice in the Yugoslavia Tribunal was to have a general expectation of what the maximum time would be that anybody was permitted to cross-examine, and then to depart from that only where the defence have given an indication, or the prosecution if it's the other way around, that they're going to need longer for a particular witness, and that is at least a benchmark. But obviously, one doesn't want to see cross-examinations expanding to fill up the space. But it's an option that does focus the minds of all concerned, and including the cross-examiner, and maybe something that the trial chamber would want to give consideration to. I'm sorry,
That was my fault. I didn't have my microphone on. Thank you. We have discussed this, and it'll continue to be discussed. We have not made a decision right now about limiting cross-examination, but it is something that we have to think about. So thank you for reminding us of that. And Mr. Young, anything to add?
Yes, nothing to add to what Mr. Keogh said. Thank you. All right.
And from the
Your Honor, thank you.
Defense.
Mr. Ellis will address you on this item.
Thank you.
Your Honour, simply to say that from the first 40 witnesses, there are a variety of witnesses, some of whom I anticipate cross-examination will be relatively swift, but there are others for whom it may well be more extensive. We of course have heard what the court said about cooperation, and it's certainly not my intention, speaking forth, simply to repeat questions that have been put by others. We'll avoid that, Your Honour.
Thank you very much.
Your Honor, may I just follow up on one point just to bring it to the court's attention. There may be instances where, with the court's permission, we would change the order of cross-examination. For instance, if it pertains to a particular accused more than others, that counsel may start first. It just, again, would shorten the cross-examination for anybody that follows.
Thank you. That's a good idea, and we encourage it. Now, Mr. Laws, I ask you the same general questions. You've seen the 40 witnesses and have given some thought to this, I'm sure. Can you give us some general estimation of your view to cross-examination of these people and the time limits?
Yes, Your Honour, I certainly can. Very limited is my time estimate.
Thank you. That's a great answer. Yeah. Mr. Laws, another question. Are you planning to file a pretrial brief in this matter?
Your Honour, no, we're not.
You are not?
No.
Okay, thank you. Well, it is almost 12. We estimated that fairly well. So we will take a half-hour break. We'll just make it till 12:30. And we will come back, we will have some brief orders, and we'll take up the request for a private session or a closed session and deal with that at that time.
All rise. All rise.
Be seated, please. First of all, we will honor the request for a private session for protection of witness identity at this time. And so, Madam Court Officer, please take us into private session.
Your Honors, we're now in public session.
All right. Mr. Emerson, when we go into private session, you will not be able to hear us on Zoom. So what we will do is, but I believe we can hear you. You just can't hear us. Is that correct, Vicky? Neither of us can hear. Unfortunately, neither you nor we can hear each other. So, is somebody else in your group able to make your submission?
Not exactly, but I can. May I indicate that I can make my submission without referring. Well, I don't know the identity of the witness who it concerns, and I do not need to refer to the witness numerical cipher either, nor do I need to refer in any detail to the content of his evidence, and so, or their evidence, I should say, because I don't know, I make no comment at all on the witness themselves, but simply on the fact that of the issue that Your Honour's already drawn attention to.
Unless there's an objection to that proceedings, and I guess it would have to come from you, Mr. Holling.
Just to state our concerns for the record, at the last status conference, there was a similar issue that Mr. Emerson raised. We needed to do redaction orders. It was perceived as public and it wasn't. There was then a written application where the public redacted version needed to be reclassified following that status conference, and this is decision F-01150. We don't want to preclude Mr. Emerson from making the submissions he wants to make, but we would suggest it would be safer if this be a written confidential application that we could respond to.
Oh, well, that's going to be way too lengthy. We're going to trust you, Mr. Emerson, to go ahead with this.
Thank you.
But please be cautious.
I will be very cautious, perhaps speak a little slower than I normally would do, so that if any objection is to be raised, it can be raised in the course of what I'm saying, but I don't imagine there will be. As Your Honour indicated earlier on, there is one witness who affects a significant redaction on the indictment, And the supporting evidence from that witness is also very significantly redacted as far as the defense is concerned. It's because the redactions in the evidence correspond to the almost entire, I think the entire redaction in the count on the indictment. It's makes no it's not in any sense a surprise to say that the witness is the only or prime witness who speaks to that count. And we don't know what that count involves, but we do know from what has been disclosed that it includes a direct allegation against two of the accused, one of whom is my client. There is, as you will have appreciated, I think, from reading the pre-trial briefs and from some of the submissions that will have been included in the transfer material, there is, as far as that witness is concerned, there is very little other direct evidence of participation by Mr. Vasili in any of the events alleged on the indictment. So this is an important witness. That's really all I need to say about the witness themselves. They are a witness who, depending on what it is they're alleging, is a witness that the defense would very much need to be in a position to properly prepare for. And we don't know the date, we don't know the place, and we don't know the details of the allegation. Now, with that said, I hope it will be apparent that that is one witness for whom the interrelationship between the various issues that have been discussed over the past hour and a half or 2 hours need to be considered in terms of the implications on that specific witness. And as presently postulated, and may I say, this is the only area in relation to a particular witness where the framework that Your Honour has proposed in terms of disclosure may raise a problem, especially if the trial starts on the 1st or the beginning of March. Because with a witness of that centrality and importance to a particular accused, such that there's a count on the indictment that depends wholly on that witness's evidence because the count itself has been redacted, clearly it's impossible for us to know for sure, but it's likely that something of that nature will require considerable focus in terms of investigation. Now, at the moment, he's one of those witnesses who falls into the category of a witness whose unredacted information is to be disclosed 30 days before they testify, rather than 30 days before the start of the trial. And one, I think, would immediately see if that were to happen in the middle of the trial, it would place the defense in a very serious difficulty and could indeed cause a situation where we would need to ask the trial chamber to adjourn while we investigated at that point, adjourn that witness's evidence while we had the opportunity to properly investigate it. It's not simply one count of many, it's the only count where there is potentially evidence that directly involves the commission of a crime as it is alleged against Mr. Vasili. So that leaves us in this situation. I mean, we would normally expect to have, I would hope, 2 months minimum to investigate a witness of that nature, so central. At least to investigate the count, to know whether it raises alibi issues, to understand when it happened and so forth. And to find other witnesses that may be able to contradict or undermine. At present, so the defence wrote to the prosecution by email 2 days ago, indicating that in respect of that one witness, we would invite them to consent to a variation of the protective measures so that we could have that witness, and this was our opening bid, 90 days before the start of the trial. The response, and I'm not criticizing it, but the response is simply to say that the basis for the protective measures remains, despite the fact that the case has been transferred to the trial chamber now, and that any disadvantages to the defence by not having sufficient time to investigate could be mitigated by calling that witness very early in the trial as one of the very first witnesses. And that, which is one of the suggestions that Your Honour said earlier on, might dovetail in certain circumstances. And that would then result back to a situation where we wouldn't have the evidence even 30 days before trial, but we would have it sometime, because there'll obviously be opening statements, and then he may or may not be the very first witness. But either way, it'll be less than 30 days before trial, just as we are all gearing up to prepare for trial and opening statements. And so if it were any other witness, and it was simply a question of scheduling and being flexible about the way in which it's handled, adopting a proportionate approach to the importance of their evidence, then I'm sure we would find a practical way of dealing with it. But this is not any old witness. It's the one witness who, according to the prosecution, alleges the participation of Mr. Vasili in a crime on the indictment. And the implications could be very far-reaching. We note that in the submissions made briefly this morning by the SPO, the point was made that this was a highly protected witness. In other words, it was a witness who was regarded as being highly important, at least that's how I understood it, to the SPO's case, which chimes exactly with what I'm suggesting about the importance of that witness, and above all, the importance of the defence having a proper opportunity to conduct the investigations that would be necessary to find out or to properly test whatever allegations are coming down the line. So that's the problem. The various solutions there seems to me to be three possible solutions, some of which have been canvassed in a general sense, but not in a specific one in relation to this witness. The first is to bring disclosure forward, so that instead of saying it must be disclosed 30 days before the start of the trial, because that would take us to the beginning of February, with the trial starting at the beginning of March, so the problem doesn't resolve. The second would be to put the trial date back to the end of March, hence the connection that I was obliquely drawing earlier on between this problem and the start date of the trial, because if the start date of the trial was the end of March, then we would have March and February if you kept the date of disclosure as it is today. The third possibility, and you want to canvassed it a moment ago, would be to start the trial formally with the opening statements, but then to adjourn the evidence, or at least that witness's evidence, so that we had a proper chance to investigate it. But if we're sitting for a 3-week block in the middle of that, it'll be difficult to take instructions. It'll be difficult to go to Kosovo. It'll be difficult to interview witnesses. And he's the witness who, or one of the witnesses with whom the prosecution wishes to front load its case. And so, without taking any further time on it, that's the problem. The SPO's reaction to that last alternative was to say, no, they wish the opening statement to be followed immediately by the calling of the evidence. So that's their position in relation to that. They also resist the solution of disclosing it before varying the protective measures so it could be disclosed now or at the beginning of January. So we have the time up to the trial date. And the prosecution's position is the trial can start on the 1st of March. The net result is, I mean, just on relation to this one witness, there is a danger of the defense being bounced trial by ambush to deal with what could turn out to be an extremely important witness at a very early stage of the trial without it being properly investigated.
Is that all, Mr. Emerson?
Yes, right. Any one of those three solutions would work as far as...
Let me ask a question of the prosecution, and Mr. Fernandez, you spoke on this earlier. Do we know when this witness that Mr. Emerson's talking about is intended to testify? I mean, can we not put that off for a period of time so that these people have an opportunity to know who it is? And we're going to make you release the name sooner or later anyway, so... I see that as a simple solution, is to not put him in the first 3 months worth of testimony.
Actually, Your Honor, I think one of Mr. Emerson's proposed three solutions would work even more elegantly than that. First of all, just preliminarily, we would like to thank Mr. Emerson. He described this at a level of abstraction, and we do appreciate it. This is one of the top 40 witnesses in the witness order.
Yes.
From what was discussed before the break, it sounds like it's Your Honor's intention that on the 30th of January, we would need to provide all of the lesser redacted documents for, amongst others, our witnesses with 30 days delayed disclosure before testimony.
Yes.
So when Mr. Emerson says the first is to bring disclosure forward, so instead of saying it must be disclosed 30 days before the start of trial, that is actually something that would be covered by Your Honor's order. And so we can accept that arrangement. The only other thing we wanted to mention, this is a redacted paragraph of the indictment that is being discussed. This is not the only witness for that paragraph of the indictment, but the indictment as well will be made available on the same day.
Well, there's another problem. We're only dealing with 30 days, and he's indicated that's going to be difficult. Does this witness have to testify at the very beginning of the trial?
Your Honor, it's our submission that one of the reasons why this witness needs the level of protective measures that he does is that he is at risk of interference. And so we believe that it's very important that you hear this witness's evidence, and we are intending to call him early in the trial so that Your Honors can hear his story.
Mr. Emerson?
Well, I mean, the concern I have about the stance of the SPO, as you rightly say, partly that cuts down the time that the defence is in a position to investigate to 30 days whilst we're all gearing up for opening statements in the start of the trial, and other witnesses as well are being prepared. But also, I mean, this is not a criticism, but the effect of what the prosecution is seeking to do is to give the defence the shortest possible time. I mean, it's justified, it is said by the prosecution on the basis of the need to avoid interference or protection of the witness. Obviously, we have nothing that we can meaningfully say about that because we don't know anything about what's alleged against us. But the concern that I have is that any of the solutions offered by the prosecution are necessarily intended to ensure that we are not in a position to have more than the absolute minimum time to investigate. I don't know. That's not to make. I'm not saying
that might be a bit unfair, but I understand your point. I understand your
It's
point.
intended to be part of the protective regime that we should have the information for as short a time as possible before he testifies. That, I think, is fair.
Okay, well, we understand the issue, and I would encourage you two of you to continue to talk about this. There are some alternative solutions that we suggested you might want to explore, but if you can't, we'll make the call, you know.
Very well.
That's
I
what
mean,
it's gonna be.
as I say, there are 3 solutions, and I'm happy with any one of them.
Thank you, Mr. Emerson. Mr. Kehoe, is this a different subject or the same?
This is a different subject.
Okay.
Should I move to the?
Absolutely.
I do believe that based on our discussion on this topic before the pretrial judge, that it has to go into closed session at this point.
Okay. You understand you're not going to be able to hear his discussion? Mr. Ennis? Ms. Alejandra, do you understand that? All right. We will go then into private session.
Your Honors, we're now in public session.
Thank you. Judge Matro had a question for Mr. Halling, I believe.
I believe it is Mr. Halling, but to the prosecution in any case, Mr. Kehoe might not be prepared to admit to how quickly he reads, but he might have a point when he suggests that 46,000 pages of new material, although it's been disclosed in another form already, is quite a challenge for anyone to read within a short period of time. My question to you, or questions, is this: would you be in a position to identify when you will release the material 1 month for trial, what material within these pages have any bearing on your first 40 witnesses? And what I have in mind in particular are any statements or proposed exhibits that you plan to use and or to seek to tender through any of these witnesses. In other words, to try to facilitate the work of the defense and of Mr. Laws, I'm sure, to try to identify within that material what they should give primary focus to. The second question has to do with the witness that was just mentioned a second ago by Mr. Kehoe, and the question here is whether there would be any difficulty in this witness being called towards the end of your first block rather than the beginning of that first block. In other words, that if there's a need indeed to interview the witness, subject of course to what the appeals chamber will say on the conditions under which this can be done, whether you could accommodate a later date for that particular witness.
Thank you, Your Honor. I'll give an answer and hopefully it will hit all aspects of your questions. In terms of the 46,000 pages, when things are disclosed in legal workflow, relations are made to witnesses in the course of that disclosure. So in the ordinary course of events, some of the connections that Your Honor is describing will be made. I'll also mention that any applications, say, pursuant to Rule 154 within these witnesses, we're intending to file our first Rule 154 applications prior to the commencement of trial. That will identify all of the statements and the associated exhibits for these witnesses that we would be intending to tender under that rule. In terms of the witness that was discussed by Mr. Emerson, for the reasons that we were stating, we think it is very important for this witness's safety in securing his evidence that he is called as closely as 30 days before testimony as possible. We have already accepted that for this particular person, something closer to 30 days before trial, in line with Your Honor's intended order, is something that we can accept. If upon receiving the lesser redacted documents, the defense wants to make a substantiated application to move that witness in the order, we could respond to it in kind. But for the moment, we would say that this is a hypothetical issue, and we would like to wait until it actually arises before actually responding.
Thank you.
Anything else before I get to the oral orders?
There's one last subject, Judge. I can take it after the oral orders.
No, go ahead.
It has to do with the pretrial release, Judge, depending on where we are, to revisit that particular issue.
Microphone, please. Microphone.
This has to do with the issue of pretrial release. Our clients have been in custody, as Your Honor noted at the outset, for over 2 years, and at least we could accommodate some ability for them to go back home for a period of time under the protective measures that we've outlined in detail before the pretrial judge. That means 24-hour-a-day monitoring in their particular locations, or some type of facility in a third country. I know that we just made a filing again before the pretrial judge on the most recent notice by the SPO. It's the same stuff all over again, much of it which is unsubstantiated, frankly, much of it which comes from the witness that I was talking about previously, believe it or not. And I can establish that by connecting the dots with statements made during the course of prior proceedings by Mr. Smith and others. That being said, Judge, I would like to entertain that as a proposal to Your Honor, and just look for guidance as to how we bring that before the chamber.
The periodic reviews are ongoing and continue to go, and we will carefully examine them as we are two of them right now. And we'll make rulings. Your position is well stated, and we will consider all of those items. Thank you.
Thank you, Your Honor.
The first oral order.
I'm so sorry, Your Honor. I do apologize.
I'm sorry,
Your Honor,
Mr. Lawson.
there was one matter that I wanted to raise
Yes, go
on
right
behalf
ahead.
of the victims in this case, and it's this. It's a matter of some importance. As of today, 53 victims have been admitted to participate in these proceedings. There are, as I'm sure Your Honour and Your Honour's colleagues know, 5 registry reports outstanding. The earliest in time is the 6th registry report, which was filed on the 18th of August of this year. Taking together the number of victims who are recommended for admission and leaving to one side those who have not been recommended for admission, it is a further 84 victims who, if Your Honour and Your Honour's colleagues agree with the Victims Participation Office, will be participating in these proceedings. It's obviously a significant number. We're very conscious that there are a number of different competing claims on the judge's time in a case of this kind. But we just want to highlight the issue really for 2 reasons. First of all, this. The pretrial judge, in a decision just of this week, granted in part an application on behalf of the Thaci defence for disclosure in relation to the dual status witnesses, on the basis that it is important for defence preparation for them to know who the dual status witnesses are. And plainly they will want to know, and we will want to know, before the trial starts. So that's the first way in which these outstanding reports are relevant. And the second, Your Honour, is much more simply this, that for the individuals most affected by those applications, that's to say the victims themselves, obviously they want to know as soon as is possible. So I hope Your Honour doesn't mind me taking just a few moments to describe that issue and to do what I can respectfully to promote it up the agenda.
Thank you, Mr. Lawson. We are aware of the numbers and have discussed already preliminarily, I mean, we just got the case yesterday, preliminarily discussed a method of getting to those issues and getting them decided. All right?
Very grateful to hear that.
Hopefully
Thank
we will
you,
do
Your Honour.
that as soon as possible. So on the working language, the first oral order. In accordance with Rule 8, subparagraph 3, the panel determines that English shall be the working language for the trial proceedings in the present case, and that the parties and participants should otherwise continue to comply with the directions contained in the pretrial judge's decision on working language of 11 November 2020. The second oral order deals with a proposed order on the conduct of proceedings. At the present time, it is a draft order and is in the process of completion. In accordance with Rule 116, Paragraph 3, a draft of our order on the conduct of proceedings will be circulated to the parties as soon as the panel is able to finalize the draft for your consideration and submissions, and we expect that to be very quickly. The parties, as well as counsel for victims, are invited to make submissions to comment upon the draft order on the conduct of proceedings by 13 February 2023 at 4 p.m. We do not expect from you a paragraph-by-paragraph commentary on the draft, but instead expect you to focus on any contentious issue. The parties, as well as counsel for victims, shall identify in particular 1, any objection they may have to any of the proposals made in the draft order on the conduct of proceedings, and 2, the basis and authorities to support any objection. No responses will be entertained. The panel will address any residual issue with the parties, if necessary, before issuing its order. I believe I said January. February. Oh, I'm sorry. January 13th is the date for the response. I'm sorry. Third oral order. The panel is still satisfied that March 1st is appropriate for the start of the proceedings, the trial. However, the following order is intended to deal with some of the concerns raised by the defense concerning timing. The SPO is ordered to provide to the panel and to the other parties and participants by the first day of February 2023 at 4 p.m. the list of the first 12 witnesses it intends to call to testify, or those witnesses which will be heard during the first 3 weeks of the case, whichever is the greater. The SPO filing shall indicate the following in respect of each witness: the name and pseudonym of the witness, the order in which the witness will be called, all prior statements or transcripts of evidence of the witness, whether the SPO proposes that the witness should give evidence partly or wholly live, and whether the SPO intends to tender the witness's statement or transcript of evidence pursuant to Rule 154. 5, the issues, facts, and circumstances in relation to which the witness will be examined. 6, the estimated time for the direct examination. 7, documents and exhibits which the SPO proposes to use with each witness, identified by their electric record number, ERN. And 8, protective measures ordered in relation to the witness with reference to relevant orders and any application for variation of such order. By the 3rd of February 2023, at 4 p.m., each defense team, as well as counsel for victims, are ordered to notify the panel and other parties and participants in respect of each of the first 12 SPO witnesses. 1, whether it intends to cross-examine the witness, and if so, the proposed duration of the cross-examination. 2, whether it objects to the admission of the witness's statement pursuant to Rule 154, if offered by the SPO under the rule, and the general grounds on which objection is taken to its admission. 3, whether it objects to the admission of any or all of the documents which the SPO proposes to use with that witness, and the general grounds on which objection is taken. Defense teams shall consult among themselves to discuss the scope and nature of cross-examination with a view to avoiding repetitive questioning and agreeing that one defense team shall conduct all the cross-examination of a witness or the bulk thereof. That's not an order to do it, but to discuss it. By the same date, victims' counsel shall notify the trial panel and the other parties and participants of those witnesses which he would wish to cross-examine, with general description of the issues or areas of evidence in relation to which he wishes to cross-examine each witness. The panel notes furthermore that it is the presiding party's responsibility to ensure that at the conclusion of the evidence of a witness, there is another witness ready to begin to testify. If one of the proposed witnesses is not able to testify at the scheduled time, or if there is no cross-examination of a witness, or if cross-examination proceeds faster than expected, the presenting party shall ensure that the subsequent witness can be called so as to avoid any delay in the proceedings. The 4th oral order. By 8 February 2023 at 4 p.m., the SPO is invited to file, if it so wishes, any bar table motion pertaining to proposed exhibits on its list of exhibits, which it intends to use for any of its first 40 witnesses. B, evidentiary material that the SPO considers important to the clear and effective presentation of its case at this stage. The SPO is not bound to tender the evidentiary material in that way, but can do so if, in accordance with the rules, it considers that doing so will reduce the amount of courtroom time which will be spent addressing the admission of those exhibits. Where such an application is made, the SPO shall 1, provide a short description of the proposed exhibits of which it seeks admission. 2, identify the proposed exhibits pertaining to the first 12 witnesses. 3, clearly specify the relevance of the proposed exhibits by reference to the relevant paragraphs of the indictment and the probative value of each proposed exhibit. And 4, provide indicators of the proposed exhibit's authenticity where the document does not on its face contain sufficient indicators of authenticity. The defense shall respond to any of such application by 22 February 2023 at 4 p.m. No replies will be entertained. The panel expects that before any such filing, the parties will have discussed the matter collegially with a view to avoid as much as possible contentious issues to be resolved by the panel. Fifth oral order, protective measures. By February 13, 2023, the SBO is ordered to file submissions on the panel's proposal to order the removal by January 30th, 2023 of all redactions in the indictment and the disclosure to the defense of the identity and unredacted evidentiary material of the first 40 witnesses. If the SBO wishes to maintain any redaction in the indictment or to withhold the identity or unredacted evidentiary material of any of the first 40 witnesses beyond 30 January 2023, the SBO shall set forth clearly for each relevant protected witness fact-specific reasons justifying the necessity and proportionality at this stage of the proceedings of the relevant protective measure. The SBO shall explain where relevant why that witness cannot testify in the first 30 days of trial. The SBO shall also identify which redactions should, in its view, be maintained in relation to the public. The defense teams are ordered to file responses if they so wish by 20 January 2023. No replies will be entertained. I'm going to repeat the first line of the fifth oral order on protective measures, as I think there's some confusion in the transcript. By 13 January 2023, the SBO is ordered to file submissions on the panel's proposal to order the removal by 30 January 2023 of all redactions in the indictment and the disclosure to the defense of the identity and unredacted evidentiary material of the first 40 witnesses. That concludes our oral orders. We have honored your request not to set scheduling orders or scheduling responses or scheduling any type of response work during the holiday period. We've loaded it up right afterwards, as you can see. But we really do welcome you all here, and we welcome your contribution. It may have been a tough morning, but we've accomplished a lot, and we will continue to do so. Specifically, Mr. Thaci, Mr. Vesely, Mr. Salimi, and Mr. Krasniqi, thank you for attending this hearing. We appreciate your presence. And I believe that concludes the hearing, unless there's something else that is on your mind.
The only thing on my mind is the witnesses that, or the motion on depositions or taking witnesses at a turn. We will be filing a motion.
You can file that,
yes.
Do that right after the recess.
Right after the recess, yes.
Thank you.
All right.